Hi guys. In my previous video on today's conference, I pinned in the comments that I would come back and do a follow-up video because um, there was some information that Matthew wasn't able to capture. It's just the nature of trying to live tweet when you're also trying to listen to what's being said. But we had more information, so I wanted to go away, find out what that was, and then come back and do a follow-up with sort of the missing parts from Matthew's tweet. And I am back. Okay, so to clarify the length of trial time, Blake Lively's proposal was 15 trial days, so that would be 3 weeks because it's obviously Monday to Friday. She wanted 2/3 of them. Whereas Ellen said, well, actually, we want the same as whatever you get. And that's where it sort of looked at, if Lively's asking for 15 trial days and Ellen says we want the same, that's how we got to we don't know the length of the trial yet. It could be between 3 weeks and 6 weeks, depending on how that kind of gets settled. What else was there? Okay, so I just need to pull up the docket. Okay, let's just share this. Okay, so on April 17th, Lively filed this. And basically, what she was seeking to do was, this is requesting leave of the court to file a brief letter of no more than 5 pages in opposition to and for advance ruling on, basically, Wayfarer wanted jury instructions on 2 affirmative defences that they admittedly they had not previously raised. So the first one was a same decision or mixed motive affirmative defense. And then the second one was an economic duress. I think Wayfarer then subsequently said, we will withdraw the duress. I'd have to go and look for that actually, just to double check. Let's have a look here. Yes. It's in this footnote. Yeah, so here at the bottom here, this last sentence, therefore the court should allow defendants to present jury instructions on the same decision defense. Then there's a footnote. And at the bottom they say defendants withdraw their request for a duress jury instruction. Okay, so so Wayfarer was seeking same decision or mixed motive affirmative defense in connection with Lively's retaliation claim. And they were originally seeking an economic duress affirmative defense, but they did withdraw that. Lyman has actually granted the same decision defense. So what that means is, so basically Lyman said that Wayfarer had the right to prove that Lively did things that could have contributed to to the backlash that happened, or the reasons why Wayfarer may be upset, to kind of say, look, do you know what? It's nothing to do with sexual harassment or retaliating for your speaking out about your concerns. It's because you were a giant asshole the entire time and you did all these awful things to us. So we were just pissed off with you, but it wasn't protected activity. Now, as I said, yes, Wayfarer did not actually raise this as a defence, but Lyman did actually say that Lively has had ample time to address the overriding argument, because obviously Wayfarer had been making the argument, well, you took the film, you pushed him out, you removed his credits, you threatened him, you put him in the basement, all of these things, you know. Wayfarer have not been silent on this, so it is not a surprise to Lively. And Lyman basically said she should have prepared to respond to that. And she did not. So what is going to happen now is a mixed motive instruction will be given. Yeah, Lyman's basically said, you know, because that the Lively won't be prejudiced. So we'll see more about that. I think he's gonna put something like a, you know, proper order. So we'll see it properly when we kind of get to look at that. Because at the moment, I'm going off what someone else has said that they heard because they were sat there. So I'm kind of trying to recall someone else's information that they witnessed and heard. But as there is something forthcoming that will be more formal on the docket, then when that is filed, then we can look at that properly then. What else? Lively wanted to argue that the Wayfarer complaint, so their complaint that they filed against Lively, Reynolds, Sloan, New York Times, was illegal retaliation. What that would do, because it's not been decided yet, but what that would have the effect of doing is basically forcing Brian Friedman to take the stand as a witness, and he would have to explain why did he file the complaint in the way he did. That could be a positive thing. That's not necessarily a bad thing, actually, because then he gets to state all the reasons why he felt the complaint was necessary. However, it could be right, think about this, yeah. It is it is so unusual to see an attorney for an opposing party being put on the stand whilst the case is being actively litigated. I can't even off the top of my head think of a time when I can remember that happening. It may have, but I mean, I thought I'd seen everything when Friedman's firm got subpoenaed. But the thought of putting Wayfarer's attorney, who is actively participating and representing Wayfarer in this litigation, on the stand as a witness is quite an uncomfortable feeling, in my opinion. For me, I'm finding that a really unsettling thought. I've been told that the people who were in the court also felt the same. Felt that Lyman kind of did not want that for fairly obvious reasons. One saving grace is, though, that Ellen did actually point out quite quickly that the judge said that there were facts about, the collusion with the New York Times. That, there were some quite pertinent facts in there. So it kind of legitimized the complaint, actually, in many ways, which then contradicts Lyman, because obviously he's deemed it baseless and even sanctioned Friedman. So yeah. The judge suggests Friedman. Yeah, the judge did actually suggest that Friedman gave bad advice and was a bad lawyer. Now, again, and I have said this before, I don't think either side intended to come this far. Blake Lively filed a PR complaint, and so did Wayfarer. I think, I think if Lively had filed what looked like a serious complaint, not the CRD, the actual lawsuit in New York, it was just a PR. Um, it was a PR complaint because the way she drafted it's not like anything we're taught to write in law school. And I actually, in one of my videos, I actually pulled up my first ever like kind of official tweet where I'm commentating, and it was on the New York Times motion to dismiss. And I literally said, "This is what we're taught to write. This is how things should look. What Lively and Wayfarer have filed does not look like, a properly drafted complaint, because it wasn't." So when Lively is she's filed a CRD, she's filed it with the New York Times. The New York Times have then blasted out a 4,000 piece article, which they've spent months working on. And then the world has seen her allegations. Then she goes and files an equally PR orientated complaint with New York. Wayfarer kind of, at that moment in time, the importance was on the PR and, kind of undoing some of the damage that Lively had done to Baldoni and Wayfarer's reputations. So Friedman filed what I maintain was the best thing he could have done, because if he had tried to tackle this head on seriously, Lively would have had the upper hand. She would have had the gains on the PR side and probably had the public sentiment on her side. And then us sleuths probably would not have sleuthed to the degree that we did. And we made some big finds, which have, really helped Wayfarer. They have shaped how this litigation has gone. And undoubtedly, kind of really attacked Lively's narrative. So I think Friedman did the right thing, whilst it was not necessarily a good complaint. It was what was needed to, they had to kind of undo some of the damage. And you can see the change in tone, because the early filings are very PR focused. And it was all about cramming as much evidence in to one document. There is no complaint that needs to be, hundreds of pages long. Like, that was just insane. Now the filings are far more sharper, and more effective, and you're starting to see decisions going. I wouldn't say overly increasingly, but there is a bit more of an increase in decisions going in Wayfarer's favor, and now is when it counts. Early on, it's about, oh, can I subpoena this person? Can you make them give me documents, etc., etc. Now it's what they're filing now will shape what will go into trial and what won't. What experts will be able to testify. What's the scope of their testimony? Are any subjects completely out of bounds, through the motions in limine? All kinds of things. So now we are really looking at, and obviously the jury instructions will kind of help weed out people who are not right for jury. So the motions now count for the trial, which is where these things all lead to. It's the end game. Sidebar very quickly, just because in my last video on this hearing, I think it was on this. It might have been Jed Wallace, but I was very, very sick of. No, it was definitely the hearing. Yeah, I was kind of sick of constantly being told, or having it flaunted, Lively is an A-list star, Lively stature, Lively standing, etc., etc. And I went through the the kind of movie fees for people like Ryan Reynolds, Gal Gadot, and Margot Robbie. And I was like, look, she earned $1.75 million for It Ends With Us. And before Another Simple Favor, that was her highest fee for a film. Whereas in contrast, you had, Margot Robbie and Gal Gadot were sort of commanding between $12 and $20 million per film. Ryan Reynolds, I think, got something like 30 million for Red One, between 20 and 22 million for the first two, for each of the first two Deadpools. And it probably would have been a bit higher for Deadpool and Wolverine. But it kind of dawned on me, hold on a minute. I should have checked out Scarlett Johansson. And she actually earns more than Ryan Reynolds per movie. She earns 35 million. Well, she did for Endgame. Yeah, she earns a hell of a lot more. So, these are what I would call A-listers. Blake Lively is not. But I digress. So, yeah. The other thing that came up in the whole Friedman discussion, and whether the complaint was genuine but poorly drafted, poor advice, or whether it was like some form of retaliation, was Lively had the absolute audacity, I mean it's peak audacity, to suggest that Friedman used the complaint as, and I'm quoting here, a sham complaint to launder facts. The orchestrator of Van Zandt literally said that with a straight face. Well, she got her counsel. She paid her counsel to do it. The same counsel, by the way, who were behind Van Zandt. Part of me thinks that is damage control for Van Zandt. Because I think Lively is onto the fact that people, the public, were highly pissed off at the underhand, shady, unethical tactics that went on behind that. And now she is trying to sort of be able to bring in, she's trying to kind of reframe Wayfarer's complaint as, well, look, they did the same thing pretty much. Whereas, no, they didn't. Because, they didn't make up a completely fabricated, it may have been a frivolous lawsuit, but it was based in some facts and merit. Despite, I know Lyman said it's baseless, but no, there was facts, Lyman himself actually said technically he dismissed on technicalities, so Wayfarer didn't prove malice, that kind of thing. And I think to try and compare that to Van Zandt, where you fabricate an entire complaint just to get subpoena power to go and get the entire private communications of Jen Abel. And it wasn't just Jen Abel. People think it just stopped at the phone. It did not. The actual subpoena to Jones Works was for pretty much, anything that, incorporated Justin Baldoni, referred to the film. Now, that would have been a lot of Jones Works confidential documents too. It's not just what was on Jen Abel's phone. So, after all of that, I think Lively is oh my god, like the audacity. Just when you think she can't get any worse, she does. There is another hearing on Tuesday next week, which is expected to last 6 hours. That is going to be kind of examining the 3 social media experts. That would be Maislin, Carlotta, and Alexander, So it'd be an hour dedicated to direct examination and then another hour to cross-examination. I think Lyman just wants to get into more of what is it you're bringing, what are you going to be talking about. Okay, Lyman also wanted Wayfarer to advise on whether they dispute or are prepared to stipulate that Lively had a good basis for making her sexual harassment claims. And apparently he said it may affect how he rules on FIHA. So the way that is likely to look is if they dispute, that might give Lyman some wriggle room to yeet the FIHA claims. If they stipulate, i.e. they agree, they come to an agreement, then the FIHA claims would obviously stay. But then the evidence that Lively is trying to bring in for sexual harassment would not come in. I think that Wayfarer are better off disputing, because I think there's a strong case to get rid of the FIHA claims. I honestly don't think that Wayfarer are concerned about any of the quote-unquote evidence that Lively has for sexual harassment coming in, because it's nothing. It's evidence of nothing. She will argue, oh my God, it's the worst experience I've ever had. I'm traumatized. And, she'll get her Darvo expert to come in and, state all of these various terms now that apply to Lively because she's been through this non-traumatic non-event. So I don't think that Wayfarer would feel particularly threatened by whatever evidence Lively is prepared to bring in to prove her sexual harassment claims. And I think they are best off completely disputing and letting Lyman, giving him an opening to rule on the FIHA claims. Obviously, the risk is that if they dispute, but he denies the motion for judgment on the pleadings, then the evidence would come in. The three options are they dispute and Lyman dismisses the claims, or they dispute, Lyman denies the judgment on the pleadings and the evidence comes in, or they agree to stipulate that Lively had a reasonable basis for believing that she'd been sexually harassed and the evidence doesn't come in, but the FIHA claims stay. If I'm Wayfarer, I'm taking my chances and trying to get rid of those claims because I think their case is much stronger, their evidence is much stronger. Whatever Lively is dressing up as evidence is piss poor at best. Okay, the judge went on to ask what the parties wanted to remain sealed. Ezra Hudson said the birth video, Natasha Heath's birth video. Ellen apparently said, no, we're good. Let's just unseal it, which I think I mentioned, but now getting the full picture of what happened. The judge said, obviously, because of the privacy belongs to Natasha Heath, the overriding decision is that, it will be unsealed. And again, I stand by that. I think that Lively wanted it sealed to leave some mystery, have people wondering, because she's alleged, oh, I thought it was porn. I saw a woman naked with her legs spread wide apart. I think if the jury get to see it all, well, not so much the jury, because the jury will, if we, the public, if it's released to us, the public, I think we'll see then that it's actually nothing. It's been exaggerated and distorted like everything else, like the slow dancing, like the Claire Are You recording, and like all of those things. Once they become public, it was like, really? That's what you were complaining about? And that's pretty much it. So I'm gonna just stop there. But yeah, that's us all now caught up. So we'll just wait and see what happens next. I know there's going to be some motions being filed for continued sealing of the documents that have been filed so far. So I will get to them. I've still got one more opposition to Daubert motion, which I think is Richard Marks. The video has been done since yesterday, actually, but there's so much going on. I'm having to get to other things first. But yeah, after that, then I'm going to try and go through the motions for sealing as well.